right, good morning, Commissioner Butler. Could you give me a thumbs up if you can hear me? All right, great. All right, good morning. We're on the record in case number 2021-00378, Big Rivers Electric Corporation's application for the enforcement of the Commission's August 2nd, 2021 order in case number 2019-00269 pursuant to KRS 278.390. My name is Kent Chandler. I'm Chairman of the Public Service Commission and will be presiding today. Joining me virtually are Vice Chair Amy Cubbage and Commissioner Marion Butler. At this time, I will caution attendees to please set your cellular phones to silent. We are hosting this via video conferencing, and for that reason, in addition to setting your cell phones to silent, we ask that you do the following. Mute your microphone and turn off your video if you are not speaking. If you use phone for the audio and a computer for the video, you turn off computer audio. If you're in a room with several people on their own computers, please turn off computer audio for all but one computer. If another participant is in a nearby office, please close the doors between offices. Use wired headphones or wired earbuds. Keep a charger nearby in case your battery runs low. And finally, and most importantly, please alert the Commission if you are experiencing technology failure that prevents your participation at any time in the proceedings. Attorneys should contact staff at the previously provided contact information. The hearing today is for the purpose of addressing Henderson's motion to intervene. At this time, we will have the entry of appearance of counsel. Given the unique challenges of doing this via video hearing, I will also request that each party's counsel identify their witnesses at this time. For the applicant in this case, Big Rivers.
Morning, Your Honors. Mike Kurtz, Tyson Kama, Kurt Boehm, and Jody Kyler Cohn for Big Rivers. Did you want us to introduce, I'm sorry, I missed that last phrase.
Yeah, if you have factual witnesses today, you can go ahead and introduce them.
Yeah, well, if necessary, we have Mr. Bob Berry, CEO of Big Rivers, and Paul Smith, CFO of Big Rivers, as witnesses.
Okay. All right, thank you, Mr. Kurtz. And for Henderson?
Thank you, Chairman. Randall Redding for Henderson Municipal Power and Light and the City of Henderson, Kentucky, along with Sharon Farmer, Virginia Snell, John Hughes, and Clay Larkin. We do, if anticipated, which I cannot, we're not intending to call any witnesses, but I see that Brad Bickett is also on for Hempel, and Chris Heimgardner, the general manager.
All right. All right, and for commission staff?
Ben Bellamy for commission staff.
Okay. Thank you, Mr. Bellamy. So, Mr. Redding, I was just curious, our order, the commission's order, the most recent one we entered, I think on your motion to reschedule, did note that the purpose of the hearing is not to address the substance of the application, but is intended to take evidence and argument as necessary in support of the motion to intervene. I guess it was our expectation that you might have factual witnesses to support the assertions in your motion to intervene. I just wanted to make sure I understood your comments this morning, that you did not, you don't have any witnesses. Is that correct?
We do not.
Okay. All right. Mr. Redding, Mr. Kurtz, are both of you all prepared to address the motion?
Yes, sir.
Okay. Before we get to that, I want to make sure that we get through and make sure that we do all of our housekeeping here. We did not have any we do not have any additional motions other than the motion to intervene. Is that correct, Mr. Kurtz? There's no petitions for confidentiality associated with the application in this matter?
Well, I would say this, Chairman. We do not oppose the motion to intervene at all. In fact, we think that Henderson is a necessary party to the case. We have submitted for the commission's review 2 invoices that were submitted to the city pursuant to the August 2nd order that have not been paid, which are part of hence the enforcement action. So I would say that's not by nature of a motion, but those filings have been made, and we would like to talk about procedure with respect to those invoices.
Yeah, and we'll get to that. We'll get to that in a minute, Mr. Kurtz. So, and I appreciate the perspective, but we'll sort of have a few questions for you on that. So, Mr. Redding,
Mr. Chairman, if I may, this is Tyson Kamoff. We do have our motion to lift the abeyance that we filed.
okay.
Thank you.
And,
Thank you.
Mr. Redding, are you prepared to speak on the motion?
On the motion to intervene, Your Honor?
Yes, sir. We have a few questions for you. So, it's hard to, I want to make sure, it's hard to, never done one of these without the person actually being on camera. You and I know Mr. Hughes have practiced in front of the commission before, and I'm sure you're aware of what the standard for a motion to intervene in one of these cases is by regulation. It's either a special interest that's not otherwise adequately represented, or it's a ability effectively to provide the commission information that it will find necessary without unduly complicating the proceeding. And I guess my question is, under which of those 2 prongs is Henderson moving to intervene?
Well, Chairman, I would ask that Mr. Hughes add anything to this position, but the order in the 2019-269 case did not reduce, it indicated that those numbers were not being reduced to a number by the PSC. And so this process that Big Rivers asked the PSC to be the vetting agent for this activity was not addressed in that order. So now, while the appeal is pending, which we think should take precedent over these actions, Big Rivers is coming back asking that the order be broadened or addressed with additional information. And if that's going to occur, we have a substantial interest, not only in the financial aspect of it, but that directly affects the appeal, and also will require the PSC to to adopt a continuous vetting or review process to move forward, all of which would be better served as we understand what the Franklin Circuit Court does with these two unique actions. And so-
Mr. Reddick? This is Vice Chair Cubbage. Did you ask for a stay of any of our orders in Franklin Circuit?
We did not.
Why?
Well, we don't believe that's our best legal strategy at this point to ask for a stay and have to deal with, that would be an injunctive relief, which we felt would just make it more complex than we're already into a complex issue in front of the judge. This matter's been,
So you're essentially asking us for a stay. Isn't Franklin Circuit the appropriate place to ask for a stay?
there's certainly, that may be a mechanism of which we could explore, but we have not asked the Franklin, in direct answer to your question, we've not asked the Franklin Circuit Court for a stay. One of the reasons is the PSC did not establish a mechanism to address this particular issue that Big Rivers has now brought back for presenting for their costs that they claim are related to this underlying issue.
Have you presented that issue to Franklin Circuit at all? This issue of Big Rivers and the underlying costs?
We have addressed certainly in our appeal, not only on the jurisdictional side of it, but the substantive appeal that we believe the order is incorrect in both its substantive application of their breadth of the decommissioning and on the calculations, until such time as the calculations are resolved under the 2018 action, we're not going to be able to agree to the underlying calculations that Big Rivers continues to present to us. So we have presented the issue to the Franklin Circuit Court that we do not believe these costs are legitimate costs of which Henderson owes under the contractual interpretation of these 50-year contracts.
Okay, and then that then begs the question of, wouldn't it be appropriate then to ask Franklin Circuit for a stay?
At this time, we have not asked the Franklin Circuit Court for a stay. We've asked the Franklin Circuit Court to establish which is to be heard this Wednesday, a scheduling order to move this case forward.
So, Mr. Redding, I'm sort of thrown off by this. So, as I understand it, Big River's application in this matter is for the commission to do something that the commission could do sua sponte. And that Henderson's first notice of it would be when the commission filed for enforcement in Franklin Circuit Court. Right? This is already a statutory authority that the commission has to enforce its orders. And I take from your responses to Vice Chair Cubbage that you are effectively using this proceeding in order to assert that you want to stay on enforcement of an order in lieu of, effectively, having sought that stay in Franklin Circuit Court when you filed your complaint. So I'm trying to understand exactly what you plan to assert in this case that is frankly reasonably before us and not something that should be taken up if or when the commission seeks to enforce its order in Franklin Circuit Court.
Let me attempt to answer. First of all, Big Rivers filed a counterclaim. The initial part of it was that Big Rivers filed a counterclaim in this action in the Franklin Circuit Court, which appeared to be where this would be addressed. They've now withdrawn that counterclaim, and during that time, we filed that the matter stay in abeyance because we thought that the judicial economy would be better served if it's determined some guidance from the Franklin Circuit Court about which way this case is headed on the underlying substantive issues.
Yeah, but Mr. Redding, didn't you argue in Franklin Circuit that this was the appropriate forum and not Franklin Circuit for Big River's claims there? Again, I feel like we've got a chicken and egg problem here.
We certainly pointed out that there is a mechanism which Big Rivers had chosen. The problem with it is that this order that was entered in the 19269 case does not, it says we're unable to determine what mechanism will be done to determine whether or not these costs for decommissioning are valid, reasonable, fair, and just. As those come forward to be contested, we have Hempel, the city of Henderson, has a direct interest in that mechanism if the PSC chooses to expand that order to undertake that mechanism to review those costs.
But is that the relief being sought here? I guess I don't understand. The relief, as I understand it, this chairman stated was something that we could just do is go to Franklin Circuit and ask for enforcement of the existing order. We're not being asked for new orders.
If you have an established number that is fair, just, and accurate, here's a perfect example. So we get provided, when they talk about invoices that Big Rivers has provided, it's not quite that simple. We're provided with a plethora of paperwork of which we have to meticulously go through and review. The complexities, which is that Big River, some of the expenses that they are presenting are commingled, in our opinion, with the other activities occurring out at the Big Rivers facility. There are more than Station 2 is the city facility. Green still operates, and there is a decommissioned facility, Reed. The work is commingled, as one of the invoices is clear that it relates to more than just the Station 2. And if that is the case, Henderson, in order to protect its interest on this level, would need to be able to address issues of concern, both as to the reasonableness of the bill, the accuracy of the bill, the commingling of the bill, the internal labor cost that Big Rivers is placing into these documents. So we asked for Excel sheets to expedite that matter so that we can understand this vast array of information, and we have not received that. So we are meticulously going through and trying to vet these invoices ahead of time. It would be the same process we'd have to vet in front of the PSC. The PSC is going to have to hear testimony on these expenses to determine whether or not they're going to accept Big River's invoices to expand this order that was entered. The order did not enter a sum certain, and Big Rivers has come back asking for that. And so we ask that that matter be held in abeyance until such time as the Franklin Circuit Court matter can be heard. But if it's going to move forward, then we need to be involved so that we can understand and review the invoices, as it has a direct effect on us.
So if this case gets turned into the mechanism, I think is the phrase you use, the mechanism by which the commission's numbers are put to the commission's order in that 2019, I think it's 266, is that right, Mr. Bellamy?
269.
269. If the case turns into that, I appreciate from your argument there what your purported special interest is and your intent is in that proceeding. If this case is merely about the commission's use of its authority, statutory authority, to seek enforcement of orders that have already been entered, then where does that leave Henderson in terms of its interest in this proceeding, and I guess what rights and what rights it will assert and what information it can provide?
Well, I think I understand your question, Commissioner, but the order to enter the order that's been entered does not provide the mechanism to accomplish what Big Rivers is proposing to bring forward. And Big Rivers, you can see from their filings that subsequent to the order that's entered, they have filed supplemental invoices on now 2 occasions asking the PSC to adopt those invoices. That is not the order that was entered by the PSC. The PSC did not enter an order and said that they were not going to attest to the validity and accuracy of those costs. That's yet to be done. So I guess if there had been an order that said a sum certain is hereby ordered and adjudged, that would be I would have a different position than I have today.
Chairman?
Well,
can I be heard
one second.
on this?
1 second, Mr. Kurtz. I'd like to finish my questions, Mr. Redding, if you don't mind. My final question, Mr. Redding, it gets back to another chicken and egg situation. The petition to intervene, or the motion to intervene in this case, that Henderson filed, notes that on page 3 of 5 of the intervention, or the motion, that the commission has previously allowed Henderson to intervene in case numbers 2007-455, 2016-278, and 2016-269 on the basis of its contractual relationship with Big Rivers. I appreciate that seems to be the case, but if Henderson is simultaneously arguing that the contract between Big Rivers and Henderson is not subject to the jurisdiction of the Public Service Commission, then how does that contract create a special interest that would support intervention of Henderson as a party?
Because Henderson is also arguing that those costs presented by Big Rivers are not verified, reasonable, accurate, or solely related to the decommissioning expenses of the Station 2 facility.
So, and I don't want to put words in your mouth, Mr. Redding, so I'm going to ask you the question. Are you saying that while you maintain that those numbers are not rates subject to the commission's jurisdiction, you nevertheless intend to intervene if they are determined to be jurisdictional rates? You intend to intervene to assert your rights or to assert Henderson's rights as to the validity of those costs?
If Henderson is going to be asked with a judgment to pay a sum certain through an order by the PSC, then Henderson should have the right to participate and know what those costs are, whether or not they are accurate, whether or not they are related to, if they're going to be required to pay a judgment. And in fact, some of those costs may very well be legitimate costs. Now, we're maintaining they're not rates, but we're arguing that those costs, some of those are going to be related, but some of those we think are commingled. And we certainly, if there's going to be a process of which they're going to bring back new invoices, because this is going to be a continuous process, Big Rivers is going to continue to present this back to the PSC on these invoices. This doesn't end with this last supplemental filing. If we're asked to pay, yes, we think we should have an interest in contesting that payment.
Vice Chair, do you have any additional questions for Mr. Redding on this?
I don't.
Commissioner Butler?
I do not.
All right, thank you, Mr. Redding. We'll come back to you. Mr. Kurtz?
Thank you, Chairman. As to Vice Chairman Cubbage's questions about a stay, Big Rivers has repeatedly stated that it will refund any monies that were collected from the city if, at the end of the appellate process, the commission's order was found to be improper, unlawful, et cetera. So there can be no irreparable harm because of that refund protection. So therefore, an injunction or a stay would be inappropriate. As to the procedure, our testimony through Mr. Smith from day one was we envisioned that the decommissioning was going to be an ongoing process, and the commission recognized that in its August 2 order. Certain costs are established and fixed. There's Station 2 operations costs, MISO fees, these types of things. It's a fixed number of $214,399. But as to ash pond and CCR remediation, as to decommissioning, as to ongoing landfill costs, those are ongoing, like a lot of things at the commission, like the decommissioning rider that Kentucky Power has, or an environmental surcharge. So in recognition of that, what we proposed as the process would be to go to the commission with monthly, present the evidence. And Mr. Barry has been very clear to everybody at Big Rivers. Obey the commission's order to the letter, no fun and games, everything. So we're very confident that a commission review of the amounts owed to Big Rivers pursuant to the order will be found to be reasonable and justified. However, if the city finds fault with commingling or other things, then the commission would be the proper place to address that on an ongoing basis.
Mr. Kurtz, just quickly, what exactly are you asking us to do here? Because I'm still a little confused. Are you asking us to go, because I read your original petition, to be asking us to go to file an action in Franklin Circuit to enforce the existing orders, the 2 orders that are already in front of Franklin Circuit. Are you really asking for a new proceeding for these other costs to be vetted?
Well, Vice Chairman, I think we, in order to ask the circuit court to enforce, the commission issued an order in a number of issues. Some costs were fixed, some were ongoing. So we are asking the commission to, we have sent the city an invoice most recently for 1.9 million total. They've come back with 34,000 is what they think is appropriate. So what we are asking the commission to do is to review the information that we submitted to the city on an ongoing basis, monthly, and to, once that number is established, once you apply the actual amounts that Big Rivers has incurred under the terms of the August 2 order the city to pay that amount, and if they don't, then go to circuit court to enforce that specific amount of money.
Okay, so you're asking for a new order, not really enforcement in Franklin Circuit of the other 2 orders yet.
I think that is probably accurate, Vice Chairman. Yes, because what we want and what we think would make the court's job easier, and the commission is the best forum is to go through the invoices that Mr. Smith has developed pursuant to the commission's order, give your approval or non-approval to those amounts, and once those amounts are established, then the city would be required to pay. If they don't pay, then seek enforcement.
So are you then conceding Mr. Redding's point that the existing order is insufficient if we went straight to Franklin Circuit?
It would be better to have this second process in this docket that we've talked about, to have the commission adjudicate the dollars and cents pursuant to its August 2 order, with the city having full rights to contest or challenge any of Big River's monetary claims. Yes, ma'am.
Do you have any additional questions, Vice Chair?
I don't think I do right now.
Okay.
Depends on what else comes out after your questions.
Yeah, so I guess I'll just ask Mr. Redding on that point. Subject to what I can only expect to be an ongoing objection or argument that these are not rates subject to the commission's jurisdiction, is Henderson supportive of a separate docket along the lines that you and now Mr. Kurtz have sort of explained, whereby there's a process for Big Rivers to assert what costs they believe are allocable according to that commission's decision in 2019-269, where Henderson then has an opportunity to vet, conduct discovery, and I guess assert its rights as to what the appropriate amounts are?
Mr. Chairman, the answer to that is no, we do not believe that's the best mechanism. We do not believe that that's the process that should be implemented for Henderson to be able to address this issue. We do not believe the PSC is the form that should be addressing this ongoing dispute. We think these are contractual issues that are better served by courts of equity as opposed to administrative agency. But with that said, this is where we have been brought to bear to protect our interests. So if the matter is going to go forward under Big River's request, because to present these costs on a continuous basis, we want to reserve the right to dispute those costs in addition to our jurisdictional issue. And that was one of the reasons we presented back to the commission the abeyance motion to allow the other matter to be addressed so that we don't go forward. So to go forward and for Big Rivers to say, well, they can always receive a refund, that seems judicial inefficiency. The way this matter has always been for the last 50 years addressed is now being done through an administrative agency that Big Rivers is asking to review the bills to determine what's fair, just, and reasonable for Henderson to have to pay. But if it's going to go, we do not agree that that process is the correct process to do it. But if it's going forward, we want to be involved in it.
Okay. Vice Chair, do you have any questions for either Mr. Kurtz or Mr. Redding?
I don't think so. I think I'm good.
Commissioner Butler?
Not at this time, thank you.
All right, Mr. Kurtz, I cut you off. Anything further?
No, Chairman.
Mr. Redding, anything further?
No, Chairman.
Okay. All right. We will take the arguments today and Henderson's motion under advisement. It's my understanding that except for the motion to intervene, the remainder of the cases, I guess it's waiting for us to rule.
The entire case is currently in advance.
Okay. All right. So we'll take all these under advisement. And of course, if anybody seeks additional relief from the commission, we just ask that you do so in writing within the appropriate dockets. Okay. All right. With nothing else, thank you all for being here today. We appreciate your time and hope you have a nice remainder of your week. Thank you.
Thank you, Chairman.
I think you're still on, so.
Yeah. What's that? That's okay.
You're muted now, Jim.
It's a formality for us.
Yeah, you are, I mean, the entire case is currently